Number 25-1003. Heroes Technology US LLC, doing business as Snuggle Me Organic petitioner versus Consumer Product Safety Commission. Ms. Rollins for the petitioner, Mr. Shi for the respondent.
Good morning, Council. Ms. Rollins, please proceed when you're ready.
Thank you, Your Honor, and may it please the court. My name is Kara Rollins on behalf of the New Civil Liberties Alliance. On behalf of the petitioner, I've requested 1 minute for rebuttal. This case is about agency power and regulatory shortcuts. Infant safety should never yield to administrative convenience, yet that is what happened here. Instead of promulgating the infant support cushion rule under the Consumer Product Safety Act's more thorough and comprehensive general rulemaking processes, the Commission instead chose to regulate these products under the abbreviated regulatory process permitted for select infant and toddler goods. The problem with the CPSC's rulemaking approach, however, was that Congress never authorized CPSC to regulate infant support cushions under 15 U.S.C. 2056A, which only applies to durable infant or toddler products. Infant support cushions, as evidenced by the definition in the regulation, are not durable infant products within the meaning of 2056A. If I may take a moment, I'd like to describe my client's product as I believe it will be helpful for our discussion today. The Snuggle Me Infant Lounger is roughly 2.5 feet long by 1.5 feet wide. It features a padded bumper and an unpadded sling. What happens is that when you place the infant into the internal sling, it has a hammock-like effect and has the effect that mimics of the baby's being held. It's meant to be a second set of hands for parents when they're eating a sandwich, folding laundry. And as the Commission itself has admitted, products like my client's have utility for parents. Yet they regulated these products under 2056A, regulatory shortcut, and effectively, for my client's product, remove them from the market altogether. Since 2007.
Can you identify in the record where your client in the rulemaking process made the statutory authority objection?
Yes, Your Honor. That actually occurs, and I apologize, I have to look at the exact, in their comment, and this is at, I believe this is at JA 428, note 3, JA 434, JA 438, and JA 442. This is their comment.
I've read through that comment and I don't see this objection made. Can you point me to specific language where they said that this can't be regulated as a durable infant and toddler product?
With respect to the 180-day period, and this is in the comment too, they say that one of the challenges is that these products do not fall under Section 104, and that's in the rule itself. The Commission recognized that both BOPI and Heroes Technology said that these do not fall under 104 because there wasn't a voluntary standard in place. Now, we've not maintained that challenge on appeal here. That's foreclosed by this court's decision in Finbin, but they did say in that comment that they did not, these products did not fall under that rule. And critically, I think, Your Honor, what you're getting at is the question of waiver, which my friends on the other side have raised. This is a question of statutory interpretation. It's about agency power. This court has routinely, as well as others, have said that when it goes to core powers like this, and it's just a matter, it's a substantive question of what the statute does or does not permit, that it's not necessarily waived and the court can hear the challenge. We believe that it is not waived. We believe that this court's case law suggests that where is here.
There's also Supreme Court case law and case law from our circuit that says that if you don't raise a specific challenge in the rulemaking process, it's forfeited.
Well, I believe one of those concerns is that then it doesn't give fair notice to the agency. In this instance, this exact challenge was raised by BOPI, another manufacturer, and that they did have the opportunity to consider it and actually did. It's in the comments. They did respond to it and they said, no, we do have the power.
I looked at BOPI's comments and I don't see them making this specific challenge, which is that this isn't a durable infant and toddler product.
BOPI's challenge is that pillow-like products, textiles, do not fall under 2056A. And that's consistent with, I mean, now we've added more to explain why that is. We've provided dictionary definitions of that. But I think Bobby's comment is very clear. They say pillow-like products, textiles are not covered under 2056A's powers.
I mean, is there any way, is there anything about this rulemaking or the nature of the underlying statute that that can be distinguishable from our waiver cases like Delaware, South Coast, and Southern Pacific?
Yes, Your Honor. I think one of the things that comes out in the Delaware case is that was done under the Clean Air Act's limited judicial review provision. And as I understand that particular provision, it explicitly is that you have to raise it in the proceeding. Some of the more generalized APA cases, as this is, suggest that if the issue is raised before the agency and it is addressed by the agency, then it can be raised on appeal by any party. And that is exactly what we have done here. And the other thing with the Delaware Natural Resources case is that, apologies, I lost my train of thought. Is that in addition to being a Clean Air Act case, one of the things that the court says in that is, well, we're going to look at sort of the whole of the comment. And is it inconsistent? Now, if you were completely for the rule before, it would be inconsistent to come here and challenge the rule after the fact. But I think the clear thrust of my client's comment to the agency is that they did not support the rule at all beyond the registration statement, which, mind you, as we say, both in the comment and elsewhere, they already had in place a voluntary registration process and notification process to allow consumers to know if there are sort of subsequent concerns about the product. So it's not really that much of a surprise that they would say, hey, we have no problem with this one aspect that you're going to make us do something that we're already doing. But I do think that if you look at the overall comment on balance, it is clearly opposed to the rule. And I believe that
Your clients said at JA 427, we support CPSC's proposed amendment to add infant loungers to the list of durable infant products that must comply with the product registration requirements in 16 CFR section 1130. Did I say that correctly?
yes, Your Honor.
So why isn't that forfeiture or waiver?
Again, Your Honor, what the Delaware Department of Natural Resources says is we look at the comment on balance. And again, on balance, there are other statements in the comment that suggest that our client believed that these weren't durable infant or toddler products. For example, as I mentioned, J428, when our client talks about that there is a failure to provide risk-benefit analysis, risk-hazard analysis, and consumer choice analysis. Those are all requirements that would have come into play under Section 2058. And so on balance, there were concerns that what the commission was doing here wasn't in conformity with the statute and the regulatory requirements
I'm
themselves.
just asking if the comment says the proposed amendment is to add infant loungers to the list of durable infant products. Let's just stop there because it did say that.
Mhm.
Is that consistent with saying that as a statutory matter, it's not a durable infant product? How can it be added to the list of durable infant products if it doesn't fit within the statute's allowance for regulating durable infant products?
I think it needs to be read in context with added for purposes of registration. And again, I think I believe it's the next line after that, our client goes on to say that they already have a voluntary registration process in. So they're not, I think one way to look at that is they're saying we're not concerned about this particular aspect, this particular requirement of what you're putting onto us. So we're not going to comment on that because we already have this. Now, when we look at the 180-day comments, this is later in it. One of the things that they raise is the problem here is these products are not durable infant goods under 104, and the 180-day effective date is not sufficient. And so I do think that there's at least internal inconsistency within the comment itself, and consistent with this court's prior determinations, it may hear this case because, again, it goes to core statutory powers.
Ms. Rollins, even if you are able to get past the waiver and forfeiture point, what is your best statutory argument that this isn't a durable infant or toddler product? Because to me, I mean, from what I understand about what this product is it sounds a lot like the other items in the list of items that are included as durable infant products.
I would actually distinguish it from those 12 in the product list. If you look at those items, what we're typically seeing are broader categories: furniture, products that are predominantly made with wood, metal, plastic. And we're looking at the overall durability and longevity of a product. Because again, the definition as we posit it is that durable infant toddler products are consumer goods that last a long time without significant deterioration. These are textile products. They are.
Is that a soft? Oh, sorry.
So is an infant carrier, so is a crib mattress, so are parts of many baby and toddler swings, bassinets.
I think that there's a critical distinction in that these are fully comprised of textiles as opposed to having component parts that may or may not have textiles. But a critical distinction with the sling carriers, for example, is that when those were adopted as a part of the durable infant goods standard, the commission looked at the 12 product list and said, this is like those, because infant carrier is explicitly stated in the statute. And sling carriers are infant carriers. That was the analysis the CPSC adopted. What they have done here is that they have looked at their regulations for sling carriers and crib mattresses and called those soft durable goods, which is atextual. And by the way, as we outline in our papers, soft durable goods, soft durables, semi-durables are non-durable goods. Your Honor, I see my time has expired. May I finish my response?
Yeah.
And so our point in regards to that is that there's a tacit understanding with the agency itself by calling these items soft durable goods and not comparing them to the statutory category list, that these are not durable goods themselves. We believe that we respectfully request that this court vacate the rule.
Thank you, counsel. We'll give you a little time for rebuttal as you requested. Mr. Shi.
May it please the court, Mike Shi for the government. The statutory question in this case is straightforward, as petitioner's comment before the agency illustrates. The key question is whether an infant support cushion is a durable infant or toddler product. And there's no dispute that the ordinary meaning of durable is able to exist for a long time without significant deterioration in quality or value. The commission clearly explained why infant support cushions are durable under that standard. They're not disposable. They have a useful life of several years. They're often used by many children in a row, and they're resold and widely available on the secondary marketplace. And so the commission's decision to regulate infant support cushions as durable infant or toddler products under the Act was reasonable.
Are you forfeiting your forfeiture argument?
No, Your Honor. We think that, as I noted at the very beginning of my presentation, if you look at the part of the comment that Your Honor quoted, Heroes Tech made very clear that they thought that infant support cushions were durable infant or toddler products when they said that they could be subjected lawfully to the product registration requirements. And that position is incompatible with the position that Heroes Tech is staking out now. The thrust of Heroes Tech's comments before the agency was a dispute over what the mandatory safety standard ought to say. That is a separate question from whether the commission has any authority to issue a mandatory safety standard at all. And the law governing when the commission can issue a mandatory safety standard under the Danny-Keyser Act is the same as the law governing when a product can be subjected to the mandatory product registration requirements under the Danny-Keyser Act. Everything just ties into whether you are a durable infant or toddler product. And here, having taken that position, it would be odd to allow Heroes Tech to take the diametrically opposite position with respect to the agency's statutory authority.
Your friend on the other side says that subsequent language in their comment made clear that they believed that there was a separate regulatory path that the commission should follow outside of the durable infant and toddler product path. What's your response to that argument?
It's honestly quite confusing to me, Your Honor. As the commission understood that argument, it pertained to an argument that this court rejected in the Finbin case about Section 104, as I think my friend on the other side recognized during her presentation. But that kind of oblique challenge to the commission's authority doesn't step back from just the fundamental language that we've been discussing at the very first page of their comment, which makes very clear that they are, at least before the commission, they were fine with the idea that infant support cushions could be durable infant or toddler products. In fact, they said, we support the proposed amendment to add infant support cushions to the list of durable infant or toddler products.
Your friend on the other side says that VOPI made this objection, and so there's no fair notice problem to the commission because at least someone, even if we were to conclude that Heroes Technology didn't make this statutory objection, someone did, and so there's really no prejudice to the commission for us to hear this challenge. You were on notice.
That's true as far as it goes, Your Honor, but the cases discussing waiver before agencies have distinguished that situation from a different situation. And if you don't mind, let me try to set forth the two sort of strands here. There is a strand of case law saying that there's an exception to the party forfeiture rule under, ordinary admin law principles if, some party before the agency, not this specific commenter, has raised the issue. And so in a circumstance where somebody in a comment has said a thing, but the particular petitioner did not, and just didn't say anything at all about it, this court has said, well, that's fine. The agency was on notice. We will address that on the merits. That's distinct from what occurred here, and the cases talking about waiver distinguish between the situation here and that situation I just described, where one party did in fact raise the question of statutory authority. That was the Bobby Company, and you can see the commission's discussion of that at page 621 of the joint appendix. Here, Heroes Tech not only addressed that question, but took the opposite question, took the opposite position from Bobby, because there's no way to reconcile a recognition that infant support cushions are durable infant or toddler products on the one hand, with an idea that there's no regulatory authority under the Danny Keyser Act over infant support cushions at all. And in that circumstance, notwithstanding the fact that a different commenter did in fact raise the issue, the court has looked to, basic principles of fairness. It almost sounds a little bit like estoppel, the way the court has discussed it, to say that, it just wouldn't make sense to allow.
One of the other cases, that are cited for this waiver principle, they involve statutory schemes that have mandatory issue exhaustion. And we don't have that in this statute. And I wonder if that's a basis for distinguishing the waiver or forfeiture question here of a purely legal question as to the agency's statutory authority.
It's true that there's no specific party presentation requirement in this statute, Your Honor. It's not clear why that would make a difference given the reasoning of the court's decision, which turned on just basic principles of, fairness to the agency, in the sense that a party that has prevailed on a particular legal dispute, namely, is there or is there not statutory authority?
Well, the prevailing party question is interesting too, because here, I don't think the government is not contesting whether Heroes is actually aggrieved or harmed by this regulation.
We are not.
Whereas, I don't think that was the same in those other cases.
That's true, Your Honor. Like, this case is different from those cases. I think that is one way
of distinguishing it as well.
It is true. It is different from those cases in the sense that, Heroes Tech still is aggrieved by the substance of the mandatory safety standard. And in those cases, at least, you didn't have that divide. And it's true, as far as it goes, that those cases, therefore, didn't have the opportunity to address a situation like this. It's not clear to me, though, why the analysis ought to be different, even if, Heroes Tech concededly, did challenge a little bit of this rule, why they shouldn't nevertheless be held to the view of the statute that they articulated before the agency when that question was in dispute. We're not here saying, for example, that Heroes Tech can't bring their arbitrary capricious challenges to the, the content of the mandatory safety standard. And I'm happy to address those on the merits if Your Honor would like. But with respect to the key statutory question, which is whether there is authority to regulate infant support cushions under the Act, it's really hard to look at the comment that Heroes Tech submitted before the agency and come to any conclusion other than they thought the agency did have that authority. And now that the agency has exercised that authority in a manner that they don't like, they have switched their position before this court.
I take it the government doesn't take the position that we are bound in a steel company sense or something like that to do waiver forfeiture first, no matter what. I mean, in theory, we could say, it's a close waiver question. There's cross currents, but because we want to get to the merits, we can just choose to do that anyway.
We haven't raised the argument that waiver is a threshold question along those lines, and the way this court has talked about waiver doesn't make it sound like a threshold question along those lines. But, all we are pointing out is that the statutory question here is quite straightforward, and you don't just need to take our word for it. You can also take theirs.
Does the forfeiture analysis, waiver analysis, has it changed because of the demise of Chevron? Because part of the rationale for it previously was, well, you need to give the agency an opportunity to respond and interpret the statute, and that interpretation might get some deference. But in the Loper-Bright world, it doesn't, we don't ignore what the agency says, but it doesn't get the same type of deference.
It doesn't.
So does that weaken the reasoning for finding forfeiture here?
It doesn't seem like it would, Your Honor, because those cases discussing waiver don't discuss waiver in the sense of, we think the agency, will then weigh in, and then, the court will then look to what the agency says and then give tremendous deference to what the agency said. The cases, as I said earlier, sound a lot more like, they're invoking general estoppel principles of, fairness and party presentation. And those principles were not at issue in Loper-Bright and clearly survived Loper-Bright. So it's not clear that Loper-Bright had any impact on, this court's waiver doctrine.
Thank you.
Thank you, counsel.
Right. Thank you, Your Honor.
Mr. Rollins, we'll give you the 1 minute that you asked for rebuttal.
Thank you, Your Honor. And I'd like to start with the last question regarding the demise of Chevron. This is an interesting regulation where it was proposed before Chevron was ended and finalized after. So I do think there's an aspect of futility, is that I think that, and the CPSC has certainly argued, we have a reasonable interpretation of the statute. If we were standing here on different ground, it wouldn't be a surprise, I think, to anyone in this room that Chevron would have been invoked. And so in that regard, I do think that the demise of Chevron plays some role in the statutory interpretation waiver question. One thing that did not come up, and I was remiss not to mention it earlier, is that we raised this exact statutory interpretation question to CPSC in an administrative stay request of the rule. They said nothing. They simply denied the request. So it was raised to the commission prior to being raised to this court. And I think that that's a critical factor.
But after the rulemaking. In
After the
motion to
rulemaking.
stay the rulemaking after it was promulgated.
Yes, Your Honor. But it was raised to this court, and there are some cases that we cite in our paper that say if there is some opportunity for the agency to respond, then there is no waiver. And there was a substantive response coupled with the fact that BOPI did raise this during the rule. I see my time has expired. Thank you, Your Honor.
Counsel. Thank you to both counsel.
Thank you.
We'll take this case under submission.
Case number 23-5103 et al. State of New York et al. Versus Donald J. Trump in his official capacity as the President of the United States et al. Appellants. Ms. Neumeister for the appellants, Mr. Acosta for the appellees.
Good morning, counsel. Ms. Neumeister, please proceed when you're ready.
Good morning, Your Honor. May it please the court, McKay Neumeister on behalf of the federal government. I'd like to save 2 minutes for rebuttal. In providing for the Postal Service to operate more like a business, Congress expressly exempted its actions from review under the Administrative Procedure Act. As a result, district courts can only review Postal Service decisions for consistency with statutory requirements under the narrow strictures of ultra vires review. Now, for some statutory requirements, Congress created a specialized review scheme whereby parties file complaints in the Postal Regulatory Commission with direct review in this court. And where meaningful review of a statutory claim can be obtained through that scheme, its review is exclusive and ultra vires claims cannot be brought in district court. The advisory opinion claim at issue here falls squarely within that specialized review scheme. By the time the district court resolved the claim in October 2022, meaningful review was available before the PRC in this court. Accordingly, a threshold requirement of ultra-virus review was not satisfied, and exclusive authority to hear the claim lay with the PRC.
Can I
This-
ask you, there's two strands of doctrine that your submission draws upon. One is the preclusion of review because there's a mechanism set forth in the statute and that ought to be exclusive. So that's kind of the Thunder Basin Axon idea. And then there's the narrowness of ultra-virus review, and ultra-virus review is predicated on not being able to get review in some other way. What's the relationship between those two in the context of this case? Is because they're both there. One of them, I think the Thunder Basin Axon one is jurisdictional, I believe. You tell me what the government's view is on that. But then on the ultra-virus one, I'm not sure it goes to jurisdiction as much as it goes to whether you can have a successful ultra-virus claim, one that prevails at the end of the day. Tell me if that understanding is wrong, but if that understanding is right, then where does that leave us in terms of the relationship between those two strands in this particular case, and which path is the right one to go down, or is there a sequencing, or how exactly do they interrelate?
Yes, Your Honor. We think those are two completely separate, independent bases for reversing the district court judgment, and this court is able to address either of them without any particular required sequencing. And that's because whether there is an alternate scheme for review of a statutory claim in order to have equitable authority to hear an ultra-virus claim is the kind of non-merits threshold question that the court can determine without actually exercising the power to review the merits of a claim and declare the law. It's very similar to what the Supreme Court held in the Sinachem case about forum nonconveniens. Their forum nonconveniens, is there another more proper forum? That was a threshold, non-merits, non-jurisdictional determination that could come before a jurisdictional question. Similarly here, the court would be saying that there is an alternate forum that is the proper forum for this claim, and the court can say that without touching on the merits.
So then for ultra-virus, if I'm remembering right, there's three prongs to it. One of them is this one.
Yes, Your Honor.
But then there's another one, which is how clearly, is it so clear that it's outside the statutory scope of authority that ultra-virus relief is warranted? That's one of them too. I think that might be the third one.
Correct.
So that would it be then that some of them are threshold so that you can get to them first and some of them are not? Because that one doesn't seem so threshold, the last one, because that just goes to the merits of how clearly is it outside the statutory authority.
That might be one way the court wants to slice it, Your Honor. I will note that ultra-virus review is essentially the court's equitable authority and the basis for the court exercising equitable authority over these extreme claims in these extreme circumstances. And so there's sort of a quasi-jurisdictional flavor of the court's power to act that is relevant in all of these considerations. But we don't think the court has to specifically say whether the blatant violation, a clear statutory requirement prong of ultra-virus review itself is a threshold question, because I think it's clear that the meaningful review prong that we're talking about is the kind of threshold determination that the court can address without reaching the merits.
And if we do that, if we look at the meaningful review prong under ultra-virus, would we basically write the same stuff that we would write if we looked at it via Thunder Basin Axon? Is there any difference between them, or is it basically the exact same reasons that you would say it's precluded by Thunder Basin is also the reasons why the second prong of ultra-virus review is unmet?
For purposes of this case, we think the analysis of those two questions is the same. It's possible that they might differ in certain respects in other circumstances, but here the question is whether there was meaningful review to exercise authority over these claims in October 2022, and either under Thunder Basin or under ultra-virus. The answer is that there was meaningful review. Congress established this specialized scheme to hear these claims, and the PRC could have afforded full meaningful review and relief on those claims at the time.
I had a follow-up question.
We may have the same follow-up question. You said the question is whether meaningful review could be afforded in October 2022. Why isn't the question whether meaningful review could be afforded at the time they filed their lawsuit? I mean, some jurisdictional things we look at the moment that the case is filed, like standing. We don't look to see whether a plaintiff lost standing later. We might look at mootness or something later, but you seem to be saying that meaningful review, even if there wasn't meaningful review when the preliminary injunction was entered and the case was filed, there's an opportunity for it by the time the court granted summary judgment. What's your best authority that that's the way we should look at that?
Yes, Your Honor. So the question is, both of their Thunder Basin, which is jurisdictional, and ultra vires, which is a question of equity. Our argument is that regardless of whether what the court did was proper in 2020, it could not exercise this authority in 2022. And that's because the district court exercised authority in exigent circumstances at the height of a pandemic where states had to administer these impending general elections in light of various public health restrictions. And that exigent circumstance is what led the court to conclude that there was no meaningful review at the time. Now, assuming that a factual predicate like that is a proper exception to PRC review. We're not taking a position on that, but assuming that that could be an exception to PRC review, that factual predicate had disappeared by October of 2022. And so similar to other kinds of inquiries, mootness, ripeness, abstention doctrines, there are a number of different circumstances where the court looks at changing facts over the course of a case to determine whether the court lost authority to act. And specifically focusing on ultra vires review, this is a question of the court's equitable authority to hear these claims and grant relief. This court has explained in the Federal Express case that this is the narrow purpose of these claims is to enjoin specific agency action that is an extreme error that requires the immediate intervention of an equity court. Now, that question, whether this is the kind of circumstance that rises to that level, that satisfies these very strict requirements and requires this immediate intervention, hinges on the facts on the ground and whether equity is proper.
Can you cite me to any authority that says, well, if you meet the Thunder Basin kind of factors at the time you filed a complaint, if 2 years later, while your case is still pending, we reanalyze the Thunder Basin factors, and if we find that you don't meet all of them at that point, then your case is dismissed for lack of jurisdiction?
I'm not specifically aware of a case that says that, Your Honor, but the court ultimately doesn't need to reach that. If the court isn't willing to assume that that scenario is proper, then it can not decide the Thunder Basin question and resolve this case on ultra vires grounds. As I mentioned, it's a threshold question. Additionally, Your Honor, this court has said that questions of statutory jurisdiction the Steel Coat Bar does not apply to them, and that the court can assume statutory jurisdiction for purposes of deciding.
So this is a question I have. So here the plaintiffs are proceeding under an equitable cause of action, ultra vires review. The government is only challenging one part of that cause of action, which is whether there's a meaningful alternative. But I don't see anywhere in the government's brief that it's challenging another important aspect of ultra vires review, which is that the government, it took an action entirely in excess of its delegated power or contrary to a specific statutory provision. So has the government waived that argument? Is that a waivable argument in the context of an equitable cause of action? I think this is actually quite hard question, because what if the government, assume for a moment that I disagree about the meaningful alternative, could we rule on this other part of ultra vires review where the government hasn't even raised this argument?
We haven't, Your Honor, because we are focused on a different prong for purposes of the appeal. We did contest that prong in district court and simply chose not to proceed with that argument before this court. I'm not sure if we have a position with respect to whether that's the kind of jurisdictional question that the court could reach out and resolve on its own. It's not something—
It's not jurisdictional. It goes to whether there is an equitable cause of action.
Yes, Your Honor. And because this is equity—
Which isn't jurisdictional.
Right. But it is a question about whether the court fundamentally has the power to act here. And so if the court thought that that were the kind of question that even though the government has not pressed it, it could pursue sua sponte because it's a question of the court's
That's what
fundamental
I'm
authority.
asking. Do you think that we can pursue that sua sponte in a context like this for an equitable cause of action?
I don't believe we've ever made that argument, Your Honor. I'm not prepared with a specific position on that, but I do want to also just emphasize that regardless of what the court thinks about the question of authority to act such that the judgment in the entirety is improper and should be reversed. There's also the separate question of the fact that this permanent injunction on its own.
So before we get to the injunction, why isn't it the case that if it goes to whether there's a cause of action, one thing we know from Steel Company is that the existence of a cause of action is a merits question. So if the existence of a cause of action is a merits question, then why can't one side just concede it? Like all merits questions, it just seems like you made a strategic choice, and it may be because you think you don't have a very good argument on whether there was a need to go before the Postal Review Commission. I don't know what the thinking is, but why wouldn't it be that with a cause of action, a party can just submit to whether there's a cause of action, and it's not something that a court looks behind once a party acquiesces in?
That might be true, Your Honor, but I want to highlight some of the differences between ultra vires review and the fact that it is this equitable
That is my
authority.
question, like whether our equitable jurisdiction turns on all the elements of the cause of action being met, which is different from a statutory cause of action.
Yes, Your Honor, and this court has sometimes described ultra vires review as the court's equitable jurisdiction and
Non-statutory. It's called
non-statutory.
Correct. And so whether or not the fact that this is non-statutory and goes to the court's exercise of its powers in equity cashes out differently, it is not something that we've specifically considered. I'm happy to file a letter or supplemental briefing on that question if the court is interested in it.
I couldn't find any cases talking about this.
Well, I have a question that, well, I don't want to, it's along the same lines, but pointing in the other direction, which is there's the question whether, as Judge Wilkins raised, this is something that you can take a fresh look at later on in the case, depending on how it proceeds. And for these purposes, let's just assume that I'm thinking about this in ultra vires terms rather than in Thunder Basin terms. So we're talking about as a ultra vires question. I don't think the other side, we can ask them, but I don't think the other side opposed in their briefing the way that you're looking at it, which is to say, we're looking at it afresh based on 2022. As of 2022, there wasn't an exigency. So in 2022, there was this alternate route to go before the PRC, should do that. The other side obviously opposes whether that was a viable alternate route. And that I think is squarely in dispute. But I didn't read them to oppose whether this is an appropriate way of doing the analysis.
I agree with that, Your Honor. I think their brief does not oppose that this is the correct question, is what the facts were in 2022 and whether there was meaningful review in 2022. And so the court can assume that for purposes of this case. Well, that's the question, because I think we could assume that if we can assume those kinds of things when we're trying to figure out whether there's an equitable action. I just don't know that the answer is all that different from the exchange that we were just having before, because that would be an inclination, is to say, well, this just isn't disputed right now, at least for ultra vires purposes. For Thunder Basin purposes, it may be that if it goes to jurisdiction, then maybe we have to independently look at it anyway, regardless of whether it's disputed. I'm not sure about that. But for ultra vires purposes, one might say, well, for those purposes, that can be something that the other side doesn't contest, and therefore we assume it for these purposes. I think for the purpose of resolving this case, because it's not a question of constitutional jurisdiction, it's fine for the court to assume that and then reverse the judgment on the basis that there was, in fact, meaningful alternate review available in 2022. Because the question of Thunder Basin is not a question of Article 3 jurisdiction, it's statutory jurisdiction, and the court is fine to assume issues with respect to statutory jurisdiction. But I do just want to highlight.
But that's different. I mean, you're talking about the Thunder Basin route. I was talking about the ultra vires route.
Yes, and equitable authority, again, this is kind of murky with respect to the extent to which it's jurisdictional. I'm not aware of an argument that it's jurisdictional as a constitutional matter. But again, we're happy to address that further. if the-
You're
if the
right that
panel's
we
interested in
have,
that
you're
question.
right that we have cases that say, we have a couple of cases, I think, that say that you can assume statutory jurisdiction. I think there's been opinions even in our court that have called into question whether that line of cases, which I think consists of two, stands up. So I'm not sure that's the more propitious route as opposed to ultra vires.
Yes, and so the court is perfectly fine to just put that aside and decide ultra vires because the specific question that we're presenting is a threshold question similar to forum nonconvenience.
And you think on that one, it wasn't the methodology of saying we can look at it in terms of what was reasonably available in 2022. That methodological move hasn't been contested. And so we can assume that and then ask whether the ultra vires prong that is related to that is satisfied.
Yes, Your Honor, we agree with that we don't read their brief to contest that the fundamental framework of our argument. And in 2022, it was clear that by that point in time, there was meaningful review before the PRC. And we know this.
But how do we know that if, or what do we do with the district court made a finding that there wasn't meaningful review? The district court said, at the time I entered the preliminary injunction, there wasn't meaningful review, and there's still not meaningful review today. At least that's the way I read the district court's summary judgment opinion.
So I read the district court's opinion slightly differently, Your Honor. I think the district court said the first half of that in 2022, there was no meaningful review. But I don't read the court to specifically say that on the ground, in 2020, there was no meaningful review. I don't read the court to say that in 2022, based on the facts on the ground at that time, there was no meaningful review. And I'd urge the court to look at the opinion. It's pages 380 to 81 and 391, where it's talking about this prong, both under Thunder Basin and ultra vires. Specifically under ultra vires, that's 391. And all the court says is that because of the nature of plaintiff's claims and because of the impending election at the time they filed suit, there was no meaningful review. The court wasn't making any findings about the facts on the ground in 2020, nor could it have done so because the briefing was focused solely on what happened in 2020. The summary judgment briefing was completed by November 2nd, 2020. And so not only did the court, in our view, not make that holding, the record would not have supported it. And it would not be consistent with ultra vires review because ultra vires review is about enjoining a specific extreme agency action. And by October of 2022, those actions had been fully overcome by events. And we know that because of the nature of the district court's permanent injunction. It did not enjoin those actions. It issued a wholly prospective prophylactic injunction against future agency action, not the ultra vires actions that motivated its exercise of authority, but hypothetical future actions. The court would not have had the authority to enter that kind of relief under even the APA. That's a broad programmatic challenge, hypothetical prophylactic relief. The APA would not have permitted it. And it makes no sense to say that plaintiffs can get this much broader form of relief where Congress has precluded APA review and they can only proceed ultra vires.
What do we make of the fact, though, that the preliminary injunction was in place, from 2020 to 2022? I mean, could the plaintiffs have gone to the commission during that time to get relief, given that the preliminary injunction was in place?
I think they definitely could have, Your Honor. There's nothing stopping them from doing that. If their complaint was that the Postal Service had engaged in an action that violated its statutory obligations, they filed a lawsuit.
That was enjoined during that time. So what additional relief could the commission have granted?
Well, it wouldn't have affected the commission's jurisdiction to consider their complaint. The commission's relief provisions are in section 3662C and D. The commission has the authority to bring the Postal Service into compliance and to order whatever relief it determines necessary to fix issues of past compliance, as well as order fines in circumstances of deliberate noncompliance. So there were things that the PRC could have done.
PI doesn't affect the commission's authority at all.
I don't believe that it does, Your Honor. And I think it's in fact what Congress intended in setting up this scheme, that the PRC have the opportunity to use its expertise and assess whether the sole body that it regulates, the Postal Service, is acting consistent with its statutory requirements.
The PI, by definition, turns on likelihood of success.
Also that, Your Honor, yes. I think if the Postal Regulatory Commission had issued a decision on the complaint, that would have mooted the district court case, because at that point, it's the expert regulator that is determining on the merits whether or not an advisory opinion was required. And then an
Against the
aggrieved party
backdrop
could
of
have
a
gotten
district
review.
And
in
then
this
their
court.
procedural claim would be moot.
Correct,
Because
Your
the
Honor.
commission they would have asked for, the advisory, well, they would have been a determination whether an advisory opinion was necessary.
Correct, Your Honor. And if the PRC determined that an advisory opinion was necessary, it could have ordered the Postal Service to stop the changes that they had to go ask for an opinion about, to undo some of the changes that they had already made, and to wait for an advisory
It's
opinion.
actually just another question. I mean, do the commission has that kind of quasi-injunctive authority to stop actions that are out of compliance with the law?
It does, Your Honor. And the statute then in 3664 says that district courts have the authority to enforce the orders of the PRC. If there is an order from the PRC against the Postal Service telling them to stop some action or unwind some action, if the Postal Service does not comply, then parties can go to district court and ask the court to then enforce that against the Postal Service, which is the only way that Congress intended for district courts to be involved in these
Putting
questions.
aside the fact that the Postal Service and the Postal Regulatory Commission are all part of the executive branch, but
So and what about the opposite scenario? If in 2022, the challengers went to the Postal Regulatory Commission, as you think they should have, and they get the other resolution from the Postal Regulatory Commission, which is that actually there was no need to go to get an advisory opinion first. And then they want to seek judicial review of that. They could seek judicial review of that in our court.
That's correct.
And they would be seeking judicial review of that in our court in a context in which there's a preliminary injunction in place that enjoins the service from effectuating the very adjustments that then would be in play in the judicial review provision before our court.
Yes, I believe that's right, Your Honor.
And that seems fine. We would adjudicate the challenge to the Postal Regulatory Commission's resolution against the challengers, even though there's a preliminary injunction in place in favor of the challengers.
I can't speak to what the government would do at that point with respect to the preliminary injunction. It's possible we would move to vacate. It's possible that if an appeal was available at that point, an appeal was taken, the cases could have been consolidated. But ultimately, at that point in time,
They'd be in two different courts.
it would be in this court, Your Honor. If there's an appeal from a
Right, but the
PI.
preliminary injunction would be, oh, I see.
Yeah,
I'm not
yeah.
talking about an appeal from the PI. I'm just talking about the fact that there's a preliminary injunction in place.
Okay.
At the same time that then the challengers would come before our court to seek review of an adverse Postal Regulatory Commission determination.
It's not uncommon for courts adjudicating similar issues to issue overlapping relief and for the parties to continue to pursue challenges to that relief on appeal in order to attempt to resolve the question. And if this court were to definitively determine that there was no issue, that there was no advisory opinion required, that would have a lot of weight. That would supersede it, because this is the court that ultimately is supposed to hear all of these appeals from the Postal Regulatory Commission.
I looked through the regulations and implementing section 3662, and I did not see anything about expedition. You know, one of the arguments that's made is that there's this kind of this 90-day period by which the PRC kind of has to act. But that's, you know, that's not a floor, that's just a ceiling. They could act quicker, but I didn't see anything that said that like these plaintiffs could go and before the PRC and seek an expedited, you know, consideration so that they could get their final order and appeal that or petition that before the DC Circuit. Because the other aspect of this is that the statute says that they can only seek review of final orders, right? So how how does the absence, if I'm correct, that the absence of any expedited regulation and the fact that they can only go to court when there's a final order, or they can only go to district court to enforce an order, how should that play into our analysis of whether there's an adequate avenue for relief?
So that's certainly a fact that the district court weighed heavily on, Your Honor. And, for purposes of this appeal, we are not taking a position on whether or not that was appropriate at the time. But I do want to emphasize that if they are attempting to go to the commission and seek relief, if they've asked the commission to work expeditiously, I'm not aware of any specific regulation requiring the commission to, but if they are in an exigent circumstance and need relief faster than they can get it from the agency, then they can do what's common in administrative cases like that, where they could file a mandamus petition in this court at that point in time, explaining that they need the agency to act faster. And if they can meet the standards for mandamus, then they could get emergency relief under those exigent circumstances. But as of October of 2020, there were no exigent circumstances that would have made review not meaningful through the PRC. And again,
November 20, after the election, you mean?
2022. As of October 2022, when the court exercised its authority over these claims, there was no exigency and there was proper review before the PRC. If exigencies subsequently arose, they could consider mandamus at that point in time, but there's nothing in the record supporting that there were reasons why the PRC could not have acted. And again, if you look at the permanent injunction, we know that the district court actually agreed with that, because the district court didn't enjoin any of the actions that supported its review in the first place. It only issued this prophylactic injunction, which again, would not have been available under the APA, was in excess of its authority under ultra-virus review. The only thing it could have done was to issue an injunction against the specific ultra-virus actions that it identified. Moreover, it was enjoining actions that themselves might not have been ultra-virus and also might not even have violated the statute. In addition, equitable principles limit relief to relief necessary to redress the party's injuries. This injunction goes far beyond that. Plaintiffs never demonstrated that they had any future irreparable harm from future impending changes. In fact, they never sought this kind of injunction at all. This was what the district court issued sua sponte.
Thank you, counsel. We'll give you a little time for rebuttal. Mr. Acosta.
Good morning, Your Honors. May it please the court, Kwame Acosta for the plaintiffs. I want to start with the meaningful review prong of the ultra-virus test. And as an initial matter, I'll just point out that the Postal Service does not dispute that when the preliminary injunction issued in 2020, Section 3662, the administrative process that provides for complaints, could not provide an adequate relief for plaintiffs' ultra-virus claim, and because of that 90-day time frame for adjudicating complaints. They've only argued that in the 2 years since the preliminary injunction was issued, that the pandemic had ended and the 2020 general election had concluded. But as the district court correctly noted, that the plaintiffs did not only claim injuries that were related to those events. For example, Plaintiff Hawaii testified that it had adopted universal voting, mail voting in 2019, well before the pandemic, and that authority did not lapse and was fully in effect in 2022 when the permanent injunction was issued. New York likewise had expanded its mail voting opportunities. And I would just point out, the district court issued that injunction in October of 2022. And so at the time, plaintiffs faced a real threat to the integrity of their elections because the mail voting was already underway for November 2022. And the Postal Service hasn't disputed the injuries plaintiffs faced to necessary public services that also depend on the mail, pandemic or no pandemic. For example, New York City testified that the mails delayed threatened 3 million New Yorkers with prolonging the time without benefits, reducing the net amount of benefits received overall, and causing applications to be received outside the statutorily set time period. And even short delays have major consequences. A 10-day window to request a hearing if a benefit is terminated, if a benefit is reduced or terminated, and if an applicant fails that 10-day window, they lose their benefits. And so there are several allegations like this related to the administration of state and local laws that depend on the mails in good times and bad, pandemic or no pandemic.
So what about, so say it's December 2020. So I know we're focused on October 2022 because if I'm remembering right, that's when the summary judgment ruling
Correct.
was entered. it's kind of a random happenstance when the summary judgment ruling was entered, it came about when it did.
Mhm.
But that's the district court's discretion to enter it whenever it did.
Mhm.
But for your purposes, in terms of seeking something from the Postal Regulatory Commission, if we just go back to December 2020,
Right.
then the election's over.
Right.
And I want to get past the pandemic, so maybe I've got my dates wrong, but sometime in advance of October 22, was that not a time where you could have gone to the Postal Regulatory Commission? And yes, there's the 90 days, but there's not the same kind of exigency in play.
And to clarify, you're saying that a permanent injunction was issued in December of 2020, or?
No, I'm saying nothing's happened.
Nothing's happened in the case. Okay, so
The preliminary injunction is in place.
Yeah.
The case is just pending.
Right.
And then I think the government's submission is, well, during that period, at that point, the exigency had elapsed. And so you could have gone to the Postal Regulatory
well,
Commission.
as was discussed in the prior presentation, Your Honors, any matter before the Postal Regulatory Commission would have been moot because the challenge procedures had already been enjoined, and so it's not clear that
I'm not aware that the Postal Regulatory Commission, it's not an Article 3 body, so it doesn't have.
Not in that sense, Your Honor. No.
So is it actually true that the Postal Regulatory Commission would say this matter is moot and therefore we're not going to?
Well, the 3662 talks about bringing the Postal Service into compliance based on violations. But if they're currently in compliance with the postal statutes, there wouldn't necessarily be a basis to seek to bring the complaint. And I would just also point out that
Well, why wouldn't the basis be, a court has said there's a likelihood of success. And so the commission is going to then work to bring the Postal Service into compliance in part with some of the findings of the PI.
My presentation here is not to say that a complaint could not have been brought necessarily. It could have been brought theoretically, but it wasn't necessarily required in order to have ultra-virus review is the point that we're making
Well,
here.
I mean, that's the question though. If that was an adequate avenue, then you can't get ultra-virus review.
The question is whether or not it was an adequate avenue at the time the summary judgment decision was made and at the time the permanent injunction was issued. And the question that the district court was faced at that time was that there was the knowledge that the preliminary injunction was falling away. And so plaintiffs were going to have no protection from last minute changes to nationwide service that undermine their operations. And so the only thing that could be done at that point would be to issue a new injunction to protect plaintiffs' rights ongoing.
Only because plaintiffs didn't go to the commission, though. Maybe you could, if you had gone in those 2 years to the commission, you could have gotten relief.
Your Honor, it very well may be that the commission could have reviewed the complaints during that period, but it's not required to necessarily to bring the ultra-virus claim.
Doesn't that concession undermine your ultra-virus claim?
It doesn't, Your Honor, because the ultra-virus claim talks about, first of all, the relevant time period here is 2022, and we acknowledge that here. And so that, as I just laid out, the issue is what the court was making a decision about at that moment, and whether or not what the risks were for the parties at that moment. And I also stress that this is a case about the Postal Service, and this is not in dispute. Circumventing a clear command of Congress, enacting changes to nationwide service without giving due notice to the public.
That only gets you so far because the way that I read this statute is that when Congress amended all of this in 2009, I guess it was, they set forth that the PRC could address and provide relief when the Postal Service violated its statute. I mean, it's explicit. That's what 3662 says. That's what the regulations implementing 3662 say. And your jurisdictional hook of 39 USC 409 says, except as otherwise provided in this title, U.S. District Courts shall have original but not exclusive jurisdiction.
Correct.
How are we to give that except as otherwise provided in this title? How is that language supposed to do work if you say that, well, even though this title otherwise says you go to the PRC, if the Postal Service operates outside of his jurisdiction, but we can just ignore that and go to the district court instead.
No, Your Honor, we're not asking to ignore that. I think the question is it's an implied intent standard. The question is whether or not Congress has implied that the alternative procedure is the procedure that must be taken in lieu of district court jurisdiction. And I would just note 409A is an interesting revision in the sense that it specifically addresses the kind of claim that we've brought here. It says that those claims can be brought in district court, and that's an important textual.
Why does it say these claims can be brought in district court? It says except as otherwise provided in this title. And in this title, it provides a mechanism for you to bring this sort of claim before the PRC and then get review in the DC Circuit.
That alternative procedure does not indicate or create the inference that the Congress intended to cut off district court jurisdiction. And there's several arguments in support of this. And one is that the question is whether or not the overall statutory scheme evinces an intent to cut off the district court jurisdiction. The 3662 complaint process says may lodge a complaint with the Postal Regulatory Commission. The commission has up to 90 days to simply begin proceedings on a complaint. And if Congress intended for this body to adjudicate these sorts of high stakes ultra-virus claims, it would not have created such a relaxed time frame for review. 410A exempts APA review, but that doesn't
create. The 90 days isn't a floor, it's a ceiling. There's nothing that says that the commission has to wait 90 days to act.
Well, it's correct, Your Honor, in the sense that it says that the agency only has, or the commission has to begin proceedings before the 90 days or dismiss the proceedings. And I think what's important for our purposes is that there's no preliminary relief in that period. And there's no possibility of expedited relief. And
why is there no? I didn't see anything in your brief or in the district court opinion cited to say that there's no avenue for preliminary relief or expedited relief. It's just ipsy dixit. We say there isn't, so there isn't.
Well, Your Honor, there's nothing in the regulations, and the government has not disputed this argument that we've been raised in. And so I would just point out, I'll give an example. So the government points to several complaints that were brought before the commission that raised 3661B. And indeed, one of those complaints sought an emergency injunction. And it's just notable that in that complaint, this is on page 42 of their brief, the complaint was filed on March 15th, 2022. The emergency injunction was filed on April 30th, 2014, and it wasn't adjudicated for more than a month later on June 5th, 2014. So they have brought forth examples of situations where the commission has failed to adjudicate these things on an emergency basis. And we're not aware of any examples where they were able to successfully adjudicate these things on an emergency basis or anything requiring them to adjudicate these things on an emergency basis.
What's the emergency if we're talking about post 2020 election? And so say we're in January 2021, December 2020, name your time. Mm-hmm. Is at that point, you could go to the Postal Regulatory Commission and their normal 90-day clock is in effect. I mean, apparently they can move as fast as a month. You just cited an instance in which they moved as fast as a month. Mm-hmm. What is the exigency going on there? And I'm thinking of it in terms of ultra vires. Is there adequate alternative mechanism? If the case is brought in December 2020, is it your view that even in that situation in December 2020, that it can be brought before the district, an ultra vires action can be brought?
Yes, Your Honor, it could be. And that's precisely because of the nature of the injuries, the irreparable harms that the plaintiffs are suffering. And I just laid those out. And we're talking about a massive change to nationwide service that resulted in a basically unprecedented drop in on-time delivery and delays that were having a constant and ongoing burden on plaintiffs' administrative processes. And so,
but what does irreparable harm have to do with it? The remedial authority is broad. I mean,
well, I think some of these injuries.
It says that the commission can order broad relief. That's what the rulemaking says. Mm-hmm. You can enforce that order if you need to in the district court.
Right.
So I don't understand why the nature of the injuries means that you can't go before the PRC.
Well, I think because the nature of the injuries it's not clear that they can be compensated in any way. I mean, we're talking about millions of people who are subject to, who require the mails in order to obtain their public benefits, just as an example in New York City. If we're
The
talking,
PRC could issue an order that says all of the same things that the district court said.
it could not say that you must stop implementing the procedures while the matter is pending on an emergency basis.
What statute or regulation tells me that they couldn't say that?
Well, there's nothing empowering them to make that determination. There's no example that's been brought forward of them making such a determination.
The statute says that if the PRC finds a complaint to be justified, it shall order that the Postal Service take such action as the commission considers appropriate in order to achieve compliance. Tell me how that doesn't
It doesn't
allow them to issue preliminary relief, permanent relief, any other sort of relief that a court could.
Your Honor, my argument is not that on the face of the statute it prohibits preliminary or emergency relief. It's just that it's not available. And as you just pointed, as Your Honor pointed out in the prior presentation, there's no regulations that provide for this. It's unclear that there are any examples for the commission that have provided for this sort of relief. And this is an emergency situation, especially when.
So in this case on that, there's a preliminary injunction in place.
Right.
So at that point, what is the emergency? Because the preliminary injunction is in place and then the provisions can't be effectuated. So if the preliminary injunction is in place, then why doesn't that give carte blanche to go before the PRC? Take your time. I mean, it's not going to be that much time because the PRC can act. And the PRC definitely has the remedies available to it that would serve your client's interests, because it can say to the USPS, you can't do this because you have to go get the advisory opinion first. You didn't do that, so stop this. Yeah, I don't think you dispute that the PRC could do.
Yeah, we don't dispute. No.
And with the preliminary injunction in place as a backdrop, then why doesn't that in itself kind of deals with the emergency? Because you got the relief from the district court,
Right.
Hold everything in place. These provisions can't be effectuated. Then it gives you breathing space to go to the PRC.
I see my time has expired. May I briefly report you? I would just say we don't have an argument here that during the preliminary injunction there was an ongoing emergency because all of these provisions had been enjoined. I think the problem there is that the preliminary injunction would have made completely unclear that 3662 would have been able to provide any relief whatsoever, and whether or not there could have been it could have been reviewable in court following an order from the commission, because everything would have been enjoined and there would be no controversy before the court. So
based on a likelihood standard, not on a
based on the preliminary injunction standard, correct, Your Honor. I mean that would be the state. That would be the. But in any case, there would be no harm ongoing necessarily to the plaintiffs as a result of the changes in the postal services. Yes.
Any further questions?
There are no further questions. We ask you to confirm. Thank you.
Thank you, Counsel. Meister will give you 2 minutes for rebuttal.
Thank you, Your Honor. I have 3 points that I'd like to try to get to. First, with respect to some of the colloquies that were happening earlier, I just wanted to emphasize that although arguments against jurisdiction cannot be forfeited, arguments in favor of jurisdiction can. And so we heard my friend on the other side say that they don't dispute the relevant time period for the inquiry of whether there's meaningful review is 2022. And so the court can follow that concession in this case. And if you look at 2022, the second point, at that point in time, the case was fundamentally different than it was when it was filed in 2020. At that point, plaintiffs wanted an injunction or support an injunction against future actions of the Postal Service, not the specific ultra-virus actions that justified the court's exercise of authority. And as this court has said, ultra-virus review is for the narrow purpose of enjoining that agency error that is so extreme that it requires the immediate intervention of an equity court. Those actions, the district court found, they were specific actions that happened in 2020. In 2022, those actions were no longer on the table. Plaintiffs wanted relief against future actions. That's not what ultra-virus review is about. And in addition, that kind of relief wouldn't even have been available under the APA, and this is not an APA case. Congress expressly precluded an APA cause of action here. And finally, I heard my friend on the other side say that even in December 2020, it would not have been appropriate to require them to go to the PRC because slowdowns with the mail continue to cause harms to them at that point in time. But that's the kind of argument that any user of the mail could always make, that if something the Postal Service is doing is slowing the mail in some way that's harming their use of the mail, the result of that would be that claims would never be channeled to the Postal Regulatory Commission. And we know that that's what Congress intended by setting up this specialized scheme that ensures that the Postal Service's expert regulator has a role in saying whether or not they're complying with the statute. And then that question would ultimately be reviewed by this court. I see that my time is up. If there are no questions.
Thank you, counsel. Thank you to both counsel. We'll take this case under submission.
Case number 24-7132. Mary E. Chambers, appellant versus District of Columbia. Mr. Branch for the appellant, Ms. Johnson for the appellant.
Morning, counsel. Mr. Branch.
Good morning,
You're
Mayor.
ready.
May I please support? I'm David Branch, counsel for the appellant, Mary Chambers. This is a Title VII sex discrimination claim. As the court is aware, this is the district court granted summary judgment on the sex discrimination claim. It arises from a denial of a transfer in 2010. The district court granted summary judgment, essentially finding that male employees identified by the plaintiff were not similarly situated. So there are really two issues here. One is an issue of context, and the other is the issue of pretext. We believe that the district court erred in granting summary judgment because the male employees were similarly situated. They were materially situated. They were not obviously identical, but they were situated in terms of having the same position. The client was a support employment. I forgot the title. Let's see. Support enforcement specialist, my apologies. The male employees that were identified were in a similar position. The male employees were accused of engaging in pretty serious misconduct. The plaintiff previously requested in 2008 to be transferred. The request was denied because it was alleged that she was needed for to perform specific duties. But in 2010, she was no longer performing those duties. She requested the transfer. It was once again denied.
With the comparators, with males who were transferred, they didn't ask for a transfer, right? They got transferred because of the disciplinary problem?
Yes, Your Honor. There were disciplinary or allegations of conduct issues with the male employees, but the record is that.
It just seems like a pretty materially distinct situation when the predicate for the transfer is a disciplinary problem, as opposed to a request for a transfer that's denied.
Well, Your Honor, I think the evidence in the record is that the Office of Attorney General permitted many employees to transfer, and it was done basically whenever it was requested or whenever it was the office determined that a transfer was appropriate. There were doesn't seem like there were any impairments on transfers other than the request made by Ms. Chambers. And I think she provided a statement that over a period of time, she requested maybe 20 transfers, and all of the requests were denied. But in the same year, 2010, these two male employees were moved out, were transferred to different positions while her request was denied. And she alleged not only her, but other female employees had their requests denied. So the question is whether when the employer offers a justification if that justification has been discredited. And here it was, or at least we believe it was done to an extent that it raises an issue that should be presented to a jury. If the employer's explanation is discredited, and then there's other evidence of discrimination or evidence that could support an inference of discrimination, and that was certainly the case here. Not only did were the male employees permitted to transfer, as you've, Court just noted, they had serious performance issues or conduct issues, and they were allowed to transfer. And then there's other evidence of just pattern of discrimination, particularly against Ms. Chambers. She was falsely accused of some type of misconduct with someone visiting the agency, and I think she was suspended for 4 days for that. And once again, male employees who engaged in far more serious misconduct, they were permitted to transfer or move to other positions. Just a couple of other additional issues that I'd like to raise. The district has taken the position that this was due to staffing needs, that the denial of the transfer was due to staffing needs. Once again, we believe that that's been discredited, or at least an issue for the jury has been raised on that point, because she disputes that there was still a need for her presence in this position in 2010. In fact, her statement to the EEOC and sworn testimony was that in 2010, she was no longer performing these duties that the agency determined that she needed to perform in 2008. So the question becomes, if you're keeping her in this position in 2010 because you claimed in 2008 she was performing some critical duties and those duties are no longer there, that the district's position has been discredited, and then the question becomes whether there's any other evidence from which a jury could infer some type of discriminatory treatment. And we have the history of what happened to this employee, just a number of issues from the time that she requested the transfer, the incident with the being suspended for 4 days. She's also alleged that at least one male employee received either some type of award or some type of benefit, even though the employee worked in the file room and was a fairly new employee, but she was a long-term employee and not provided any type of special benefits provided by the employer. There was also, I think we addressed this already, but there was this issue of whether these two male employees were similarly situated. And it's our position that they were at least similarly situated in their titles and in the timing or the time period when the actions were taken. There was also an issue raised about the women. There was an allegation that the discriminating official, Ms. Rice, permitted 16 women to be transferred over a period of time. And I believe under the Supreme Court decision of Reeves that Title VII addresses individual acts of discrimination. So the fact that women were permitted to be detailed or transferred does not undercut any claim that Ms. Chambers has. Especially when there's evidence that she was denied the transfer and a number of male employees were granted transfers. So the fact that some women may have been permitted to transfer does not undercut her claim. This is just another claim that should be presented to the jury. Once the chief reason offered by the employer is discredited or undermined, then it opens the door for other evidence of discrimination. And the type of evidence that was presented before the district court is the type of evidence that's routinely presented in employment discrimination cases. Hey, I was denied a transfer or action was taken against me. Other employees who are similarly situated were provided more favorable treatment. There's a shifting.
Can I just, I want to zero in on something. You say that the reason for denying the transfer was discredited in the district court. And can you just zero in on what that reason was and how was it discredited?
I missed one word that you said, what that reason was.
What was the reason and how was it discredited?
So it was, the district court essentially found that the male employees were not similarly situated.
No. You said that the office, the employer, gave a reason for denying the transfer and that reason was discredited.
Well, the argument that's being made is that that Ms. Chambers was needed in this office for whatever staffing reasons or to work on a particular assignment. I think there's an email from Ms. Dewberry in the joint appendix where she does a draft letter and she says, I'm going to send this letter to Ms. Chambers to deny her request to transfer. And that's sent to Ms. Rice. But the justification, basically, the explanation was she's needed in this office to perform whatever duties are being performed in the office, when in fact that was not true. Ms. Chambers provided a statement to the EEOC that the duties that she had been performing since 2008 were no longer being performed. And then just later in 2000, that was 2010, but in 2011, all of the duties that were being performed were redistributed or moved around. So that undermines this claim that somehow she's needed to remain in this.
Let me interrupt for a second. We have to operate based on the summary judgment record and whether there was a dispute of fact or what the or whether the undisputed facts support granting or denying summary judgment. So what did the district court say with respect to whether this reason was discredited? Did the district court say that you had raised a dispute of fact on that, or that you had not raised a dispute of fact that was discredited?
I don't specifically recall that the district court even addressed this issue. The district court went straight to the claim of whether there were similarly situated employees. And he found that these male employees were not similarly situated for the reasons argued by the district here, that this was discipline and they were had a different reporting relationship. And that's all the district court did. The district court decided the case based on the fact that he found that there were no similarly situated male employees. Well,
it seems to me that if an employer presents, the legitimate non-discriminatory reason for taking the action, then you go to, well, does the evidence kind of rebut that and show that it's a pretext, or at least raise enough of a question of fact to send it to a jury? It seems to me that it's an entirely different kettle of fish, so to speak, if the plaintiff shows that the legitimate non-discriminatory reason that was proffered was indeed itself without factual basis or was false. Direct evidence that it's false. I didn't take, maybe I missed it, but I didn't take from your briefing that was your argument.
Your Honor, that's been one of our arguments all along. I mean, that was the basis of her claim at the EEOC, and that's always been the basis of her claim that a decision that I was in this position in 2008, 2010. I requested a transfer that was denied, and then male employees were transferred.
Make sure there's no further questions. We'll give you a little time for rebuttal.
Yes, Your Honor. Thank you.
Ms. Johnson.
Good morning. May it please the court. There are two decision makers in this employment action. There's Ms. Dewberry, who was the immediate supervisor, and there's Rice, who was the director of the division. Dewberry made the initial decision to deny the transfer because it would leave her unit short-staffed. Rice approved Dewberry's decision because Dewberry had said she needed Chambers to stay in her division. Chambers does not claim that Dewberry acted with discriminatory motive. So Dewberry has fallen out of this case. This case is now about whether Rice acted with discriminatory animus. And Ms. Chambers has offered not a shred of evidence that sex discrimination was the basis for the decision. Dewberry asked Rice to deny the transfer. She asked for approval to deny the transfer because she said it was imperative that she keep her new staffing level because there was a new reorganization that had just been announced and she needed Ms. Chambers to work enforcement cases. Ms. Chambers has offered no evidence that that was untrue. All she says today and in her reply brief, not in her opening brief, but in her reply brief was, well, I was no longer working RSR cases. Well, that's true. She was needed to work enforcement cases because there was a new reorganization. So even if the reason for her denial of a transfer in 2008, which is not before this court, was no longer in play, the reason that she was denied a transfer in 2010 has never been disputed. The district court didn't talk about whether that had been disputed because Ms. Chambers didn't offer evidence disputing that reason in the district court. Instead, Ms. Chambers relied on comparator evidence. But I would like to—
The district court's opinion was confined to the comparators.
I believe so. I mean, also this court is doing de novo review. So, I mean, the district court's—
But I'm asking for a yes or no.
I believe so. I mean, I didn't look at that question until a moment ago, but when I looked
You've read
at
the
it—
district court's opinion, I assume.
Of course I have. And I just looked it up again.
I don't remember there being a discussion of something other than the comparators, and that may or may not be fine for our purposes. But as I recall, the district court's analysis was focused on, and I think essentially confined to, whether the comparators are comparators that we ought to take into account.
Yes, because, and it says on JA 18, the plaintiff relies primarily on comparator evidence as support. So yes, the district court addressed the comparator evidence because—
Primarily.
Yeah, well,
Not exclusively.
of course, but Ms. Chambers has never disputed this evidence. I mean, I think that's the bottom line. She has never disputed that there was, in fact, a problem that would leave her unit short-staffed, nor has she disputed that that's what Rice believed because that's what Dewberry told Rice. It would be astonishing for there to be a jury question when there's no evidence in the record to the contrary. So Ms. Chambers has never— and also I want to emphasize that Ms. Chambers first raised this dispute in her reply brief. In her opening brief, she said that the reason was untrue, and then she cited evidence from the 2011 transfer denial. I believe maybe she just confused the two, but they were different reasons, they were different years, they were different denials. So these arguments that Ms. Chambers is raising today are actually forfeited in her opening brief as well. They're not in there. She never argued that because she was no longer on RSR cases, Ms. Dewberry's reason for denying was somehow refuted. So I'm happy to answer any questions this court has, but I feel like it'd be helpful if I just gave you sort of the bottom line for the 3 ways to prove animus and just the really sort of the simplest and easiest way to affirm. First, we just discussed whether the reason proffered was false. Ms. Chambers has offered no reason that Rice would not have supported her immediate supervisor's request to keep an employee in her unit. Second, comparator evidence. Ms. Chambers has confined herself on appeal and in the remand to FM and JS to the 2 employees. There's no evidence that Rice was involved in either decision. She certainly was not the decision maker in either decision. And this was not over the objection of the immediate supervisor. There was no issue where the supervisor was saying, please don't transfer this person. And on top of that, those people did not ask for a transfer. Our office does not routinely transfer people based on whether they want to. If they want to apply for a position, they can. But But these are all distinguishing factors that could easily explain and provide a non-discriminatory reason. Third, the other way that you can sometimes raise an inference of discrimination is through a pattern of discrimination, either against the plaintiff herself or against other people in her class. And I do want to emphasize that not only is there no evidence that Rice was involved in any of Chambers' prior grievances, not a shred of evidence that Rice was involved, and that's critically important, there's no evidence that the district or that OAG, the agency, discriminated at any time against any employee on the basis of sex. There's simply no evidence of discrimination in this case. And so we would ask this court to affirm.
Thank you, counsel.
Thank you.
Mr. Branch will give you 1 minute for a rebuttal.
Yes, thank you. In terms of whether there's any evidence in the record to support discrimination based on sex, the evidence is the occasions where the appellant requested a detail or transfer, and the transfer was denied, and male employees requested or were given details or transfers, and the transfers were granted. There's evidence in the record that there were many instances where male employees received details or received transfers. And of course, the issue that we have before the court is the denial of the transfer for the plaintiff or for the appellant. And there is.
What do we do if the male employees who got transfers had different supervisors than Ms. Chambers?
Your Honor, I don't think that, well, they're working obviously within the same office, and it's our position that there's a policy or practice in the office where these transfers were routinely granted, unless there's some reason not to grant the transfer. But the male employees were granted transfers when they were requested. Some, we're not saying they all reported through Ms. Rice, but there are instances where some employees who did report to Ms. Rice received transfers. And I mentioned this before, the fact that maybe some women were given details does not distinguish this case or prohibit her from moving forward with the case. Simply because some women may have been transferred. Title VII protects individual claims, and her claim is that I was treated differently because of my sex. The male employees were given transfers. Even these male employees who were problem employees, conduct issues, all of these other issues, the discipline of her being singled out, all is based on her sex. And we request that the court reverse the district court's decision on summary judgment. And, you know, at the summary judgment stage, the question is not, you know, who should win, but whether there's evidence that a jury could find in favor of the plaintiff. And we believe that Ms. Chambers has presented evidence on the record with the shifting explanations, the comparators who were treated more favorably, and the disparities in the treatment of men and women to warrant reversal. Thank you.
Thank you, counsel. Thank you to both counsel. We'll take this case under submission.
The Honorable Court of Federal Director, reminder of the unfair case.